Okay, so let's go ahead and talk about this real quick. Annie, you can pass it forward. I'll grab it. So this case, a couple of kind of elements of it. First of all, the timing of this case kind of are significant because we started seeing, time period 1947. We start seeing at least the ability to start gathering a little bit more data. And that's actually going to be important to look at application for this case because we're going to be somewhat dependent on that data in determining our math equation. In terms of kind of application of this case, again, this was a U.S. Supreme Court case. The U.S. was actually involved, and the reason that the U.S. was involved as the plaintiff in this case was because they were the leasee of the property. Just pass it forward, it's fine. So the facts of the case are as follows. On January 3rd, 1944, in the New York Harbor, the barge Anna C. was moored to the end of the pier. The cargo of this barge was flour that was purchased by the U.S. government. And the U.S. government had leased the Anna C. To move this flour to be processed. So just kind of a quick aside or a quick notation. So it's not uncommon for the government to, come into agricultural markets, and somewhere along the line, 1900, 3140, you probably looked at a lot of these different price floor markets. And flour is one that the government does have a price floor in. And during this period of time, really, and it's still done today, but during this period of time, one of the most common ways for the government to establish a price floor was to purchase the product. So, to effectively become a demander, elevating the price. We also saw another thing going on in 1947. World War II, was going on during this time period. While though not formally stipulated, the likelihood is that this flour was purchased to go to processing to provide food or rations for the troops. So the government had some interest in this flour not being destroyed. So they had purchased this flour. They had transported it to the East Coast so it could be processed into bread and then be transported overseas to be supplied to the troops. So the Anna C.'s tied to the end of the pier. Next day, a tugboat comes. The tugboat was the Carroll Tug, owned by Carroll Towing. And it was sent to the pier because it needed to tow away one of the barges that was tied onto this public pier. They were actually just a little off in where they were supposed to be. They were supposed to be one pier north, but that's not necessarily relevant. So the Anna C. was tied to Pier 52 with several other barges. What is very common is that they will tie these barges together to help stabilize them to the pier. So all of these barges are tied together in a big long string, and then every few barges they're moored to the pier. So this tug company needs to get one of these barges free. So that means they have to untie the neighboring barges. So the towing company unties the neighboring barge. They tow away their tug, all is well. As it turns out, they did not retie the barges up properly. And the Anna C. broke loose, broke free of its mooring lines due to the readjustment, and crashed into another boat, into a tanker. It dumped the cargo, so it flipped upside down, careened, that's the term they used. It careened, turned upside down, dumped its cargo, and sank. No one was aboard the barge at the time. Since the United States owned the Flower and was leasing the barge, the United States sued the tug company, claiming that the employees were negligent in readjusting the moor lines. So this goes to court. And in court, Carroll Towing made their own argument. Well, they said, well, they're not a barge company. They're a towing company. And that all barges are required to have what they call a quote-unquote bargee aboard them who inspects and adjusts all of the mooring lines. And whenever the barge sank, no one was aboard it. No one was aboard it to help readjust the lines. And so they claimed that they should not be liable because the government was also negligent. A bargee would have assured the moorings were adjusted correctly. So that's our background. The issue then for the court was whether or not the U.S. should be held liable for the damages of the lost cargo by not having an attendant on board. So essentially, the court was looking at, was there contributory negligence involved? So what did the court rule? The ruling of the court said that, yes, the U.S. was partly responsible and within the ruling introduced what is known as the hand rule. So the hand rule is named for the judge who wrote the majority opinion. The majority opinion in this case was written by the judge, Justice Learned Hand, and that's actually his real name. So Learned Hand. So I guess if you're going to have someone writing Supreme Court rules, Learned is probably a good name to have. So in his ruling, Justice Hand wrote, here's kind of the long quotes, you can just kind of think of the summations. It appears from the foregoing review that there is no general rule to determine when the absence of a bargee or other attendant will make the owner of a barge liable for injuries to other vessels if she breaks away from her moorings. Some gaps, then pick back up on his quote. Since there are occasions where every vessel will break away from her moorings, and since if she does, she becomes a menace to those around her, the owner's duty, as in other similar situations, that part is kind of important, other similar situations, is to provide against resulting injuries as a function of three variables. And I know some of you are trying to type and write, and I'll give you a second. So just kind of before we get to the three variables, thinking about kind of this long quote here, because like I said, that similar situations is important. Because in the initial element of the ruling, they're focusing on this case at hand. One case, a barge case, a river case, but then as he in his ruling wrote, and other similar situations. That is the court saying that this formula needs to be applied to these situations of negligence. So it says we're not thinking about this, the court was not thinking about this specifically and only meant to determine this barge accident. we want this applied into any similar situation where negligence might be applicable. So, I mean, it seems like it's really small. It was 3 words, but those 3 words have immense power in establishing legal precedent. Okay, so anyway, back to his quote now. Provide against resulting injuries as a function of 3 variables. Number 1, the probability that she will break away. Number 2, the gravity of the resulting injury if she does. 1 was probability, 2, gravity of injury, and number 3, the burden of adequate precaution. Judge Hand also stated this then in algebraic terms. Again, kind of interesting if you look at the full case that, you know, they do break into some of kind of the algebra for it. Now he assigned some variables to it, and then I'll kind of adjust it to kind of connect it with our variables that we've been using throughout the textbook. So in his notion, Hand said that the probability would be P, let's see, injury is L, and he called burden B. He said that liability depends on whether the burden is less than L multiplied by P. So the Hand rule mathematically. He said that liability depends on whether or not B is less than P multiplied by L. If this is true, so if the burden is less than the cost of injury times probability, the legal standard for care will not have been met.
What court was this in?
U.S. Supreme. So if B is less than L times P, then X is less than Xn equals X star. Conversely, if burden is greater than or equal to the cost of injury times probability, then the legal standard has been met. So that's kind of the mathematics in his ruling there. Let's just put that into words, into a sentence, into kind of a definition for the Hand rule. The Hand rule says that if precaution is efficient, then you're negligent only if you don't take it. The Hand rule again says if precaution is efficient, you're negligent only if you don't take it. So this isn't too far of a stretch. We've actually seen this. We've been arguing this anyway. So this is not too far removed from our textbook variables. Because in this case here, he's saying burden, the burden of precaution. Burden of precaution is essentially saying the cost of precaution. Well, we gave a variable for that. So effectively from Judge Hand, B is synonymous with our variable of W. And the gravity of the injury, it's the cost of the accident. We gave a variable for that. The probability of an accident, we gave a variable for that. So, P kind of stays the same. Px. In our variables, L, he said, is the approximation of what we viewed as cost of an accident, A. And so we were working on this, we showed this graphically. So if our variables effectively were saying that W is less than Px of A, the textbook, by the way, give that a negative term, and remember we addressed that in class, that it's technically a cost, so it's negative. Doesn't matter to me, they're technically both negative, so I didn't really care. But if W is less than Px of A, effectively saying that more probability, lower accident cost, okay, perfect, there's our inverse relationship. In essence, it says if you spent less on precaution, then the probability cost of an accident, you're liable. If you spent less on precaution than the probability cost of an accident, you're liable. If you spent more on precaution than the probability cost of an accident, you're not. So again, this is not far removed from our idea of thinking about this in terms of a minimization point. We're able to put a value to it. Let's wrap up this case. I'll give you the rest of the kind of the application and how the court then said, okay, now we've got all these variables, how do we apply them? And then we'll actually talk about some real life relevance maybe to this. So just kind of to go back to wrapping up, by the way, do I need to repeat my liable not? I said it fast. Everyone's got it? Okay. So in this case, the court ruled that leaving the barge unattended during the workday poses a significant risk. Effectively increasing the variable of P. It said it increased the probability of the accident. The cost of the accident, the court kind of felt was a somewhat constant value. The loss, the damage to the ship, the damage to the grain, and possibly the damage to the tanker, if that applied, but it didn't appear to in this case. But as the probability increased, PL as a variable also increased. And if this side of the equation goes up, in order to not be liable, this side of the equation must go up. And they said that not having someone there during workday hours made P rise. Well, then you need to spend more on precaution. You need to pay that bargee to be there during those times, effectively raising B. Because if you would have made that payment, well then your payment would have covered the cost of the accident. You would not have been liable. So it was found that the U.S. was partly liable for negligence by not paying for the employee to be on the barge. Based on this new ruling, the court then sent it back to lower courts for retrial using this new set-up precedent. Okay, so that kind of wraps up our case. Now again, let's think about this in terms of some modern day. Because this gives us really two modern day applications. And our book really focuses on one, but I also want to bring out another one. So the book focuses on the idea that, well, sometimes it still may be difficult for the court to come up with a number. Even though we now have variables, where does our number come from? And so one of the things that they talk about is the extreme amount, essentially, of tort cases that the courts see. There are lots and lots of civil claims, and all of these civil claims are going to fall into tort law at a very high clip, at a very high amount. And so the authors of a textbook, Kuder and Ullin, they say that we don't actually need an established number because there are so many similar cases that these similar cases themselves can establish a number. So one case comes before the court, and we'll go back to our car-bike example. And the court looks at this and says, okay, well, we have these ideas for probability and cost of an accident. How much have you spent on maintaining your car? Okay, we've got a number. Well, that wasn't enough. You didn't have working headlights. So that wasn't enough. The belief is that sets a precedent. Okay, you have to have working headlights or else it's not going to be enough. So then it goes to court again, and the court says, okay, well, let's look at everything, the cost of the accident, blah, blah, blah. And, oh, you did have working headlights, but you didn't have a working horn. So you still don't have enough in repair work done or whatever, in preparations done. So that sets a new precedent that not only do you have to have working lights, you have to have a working horn. And the belief that the textbook authors is because there are so many cases that do flood the system in this measure, that this is actually established relatively quickly, and that this precedent is built relatively quickly, and that we can then determine what is the court's minimum. Because then when the third case, or however many it takes to get there, goes forward, and the court says, okay, so you had a working headlights, you had working horns, and you had working brakes. Yeah, you've covered the cost of the accident. You have you're effectively in here. What you're spending on the burden of precaution, your W, if you will, is greater than that PL combination. And the court sets a precedent. And that precedent then is known by society. So society is given a value for B by default. Do this, this, this. So our textbook talks about that in terms of kind of building that precedent, and I think that works really well for probably the lifespan of when our textbook authors were really big in writing. I mean, they're both kind of retired now. Because that works great for the 50s, 60s, 70s, 80s, but now we've seen a new twist. We live in an incredibly high data age, and we've started seeing that these numbers are actually very calculatable. You guys have done them in econometrics to some extent. You have been able to look at data over multiple accidents, and you can establish an estimated cost. You can also establish an estimated cost of burden. In fact, isn't that what your econometrics is doing? It's taking 2,000 points of data over multiple variables, it's plotting them out, and you find a trend line. That's what regression analysis is showing, if I can erase this right here. Effectively, we have all of these multiple data points. And we say, okay, well, what trend can we put in here? That regression estimate, that coefficient estimate, is effectively doing this. It's saying we're going to put a trend in here, and then whenever you calculate your deviation, you're saying how far away, effectively, are we from that trend line. And the tighter you're packing, effectively we consider the stronger your variable passing that statistical test, means that, yeah, we can usually, with a lot of things, kind of find a really tightly packed trend line, which gives us essentially a calculatable value. We've seen courts turn to this. Courts more and more since the 1980s, when we really started getting big data and the capability to compute this more and more, are leaning on essentially forensic economics. They're saying we are looking at regressions done to try to calculate these values. So right now, me and a colleague of mine who teaches at WashU are involved in a court case. And I am super glad that I did not get deposed because he did. He had to go fly out there. You guys are not glad because the court ordered him to stay out there during the duration of the trial, which is still ongoing. He flew out at the start of April. So unfortunately, all his classes had to be canceled. And they had to find someone to teach it. You guys would have been okay with 2 weeks of class canceled, I'm sure. He's still out there. But what did we do? Again, without going into a lot of the details because the trial's still ongoing, but I'll tell you what I did. I did hours and hours and hours and hours of data collection on Excel. It's an employment case. Effectively, although not exactly, it's a wrongful termination case in the sports industry. That's why I was involved. If it was just labor industry, I'd probably not qualify. But it was in the sports industry. And so the first thing that we did is we gathered tons of data on employment. And then we found similar cases where termination occurred. We built all this into Excel. We then started ranking the terminations in severity. The NCAA was who hired us. So then we started looking at NCAA punishments and termination rates. We then actually even had to apply some data to society. We had to get society's viewpoints on whether or not terminations for certain offenses were more severe. We ranked based on that. Then the next step was salaries, because you don't want to just compare one person. So we found 141 other similar situations. And we traced their salary from before their work with the NCAA, and again, so it's sports, we're talking some of these people were in high school, through their work with the NCAA, and after their work with the NCAA, to get all of these formulated data points to make a trend line. So we could come up with the value. Courts are becoming increasingly more dependent on this. Like I said, it started really in the 1980s, and now almost any case that is going to involve a significant amount of money, the court's going to look for a forensic accountant or a forensic economist. They're going to want someone to build all of these money models. Because they are saying that we have an equation, and not just for negligence, but they have ones for other areas as well. We've built this equation in society. We now have the data to fill in these values. Again, that's what you did in econometrics. You came up with an estimation on probability for something. You came up with a variable value for something. We can fill in these values, which means we actually have gotten to the point where we actually can come up with numeric calculations, or at least numeric estimates for all these values to apply to the hand rule. So we're really seeing kind of a new twist in essentially the building of this precedent that is really only about 20 years old. In legal terms, that's super new. That's really only about 20 or 30 years old in terms of the application of this model. So again, it does have some bearing in its timing. There's also some instances that we could say, well, maybe the court has some difficulty applying the hand rule successfully. And so I came up with two of them. Ooh, I can't do the first one because I'll run out of time, but I could do the second one. And then we'll have to go back to the first one. So some difficulties in applying the hand rule successfully include, number one, that to remember, hindsight bias. Hindsight bias. Oh, God, I would say probably only a small chance that Hai-Long talked about it in econometrics. You might have learned it in OPM to some extent, maybe. I wish we had a behavioral economics class, because you would talk about it a lot in there. So you probably haven't heard the term, so I'm going to give you the quick, not the greatest in the world definition, but the definition that works. Hindsight bias is the belief that after witnessing a low probability event, we are more likely to overestimate the probability of the event. So after witnessing a low probability event, technically it's after witnessing any event, but it applies more towards low probability events. After witnessing a low probability event, we overestimate the probability of that event. Okay, so just kind of silly example. Let's hypothetically say that right now, any of you, if you take out $1, if you hold it up, I will sell you insurance that protects you from being struck by lightning while in this class. Because it's possible, right? I mean, you know, buildings don't prevent lightning. Lightning can go straight through glass, which means we could get a thunderstorm and you could be struck. You guys over here, a little bit more danger. So right now, I will sell you insurance. And for $1, walk up here, and if you get struck this semester, I'll give you $1 million. Anyone? Any takers? I know I should have done this at the start of the semester. We don't have much time left. No takers? Okay. So what would happen if I said the exact same thing, and well, the day before, Jacob got struck by lightning. You're closest to the window. And I say, oh my God, you guys, Jacob got struck by lightning. Okay, we need to develop some kind of protection for you in society in here in our classroom. So for $1, if any of you get struck by lightning, I'll pay you $1 million. You know what would happen? All of a sudden people are going, oh God, yeah, here's my dollar, because it's probably going to happen again. No, it's not. The statistical odds of being struck by lightning are incredibly small, and that doesn't change. The statistical odds of being struck by lightning while inside a building, while still possible, are even smaller, and those don't change. And your decision was based on that knowledge of those statistical odds. You didn't even have to know the number. They're super small. But witnessing it occur all of a sudden says, I better go ahead and do that. Courts have that hindsight bias as well. That whenever a low probability event occurs, they see it and they say, oh man, we overestimate a value. We think it's going to happen much more frequently. Screws up our formula. Okay, we'll get to the other one next time.